Back to 4111, we have a gentleman from out of the area that wanted to testify. Mr. Scott, is it Rohter?
Yes, sir.
Thank you for coming, and please welcome. Please identify yourself for the record and give us your concise testimony. And I understand.
Yes, thank you, and thank you for letting me do so. I tried very hard to get here on time, and I apologize for being late. My name is Scott Rohter, and I'm here to testify in favor of House Bill 4111.
Go ahead.
One of our famous presidents said, if you want to make enemies, just try to change the status quo. Anybody know who said that? Because I was trying to figure out. I didn't have my website with me on the way up here. But for too many years, this law, ORS 223525, has been the law in Oregon. It's long past time to revise it. Jack and Betty Neely say it's 15 years past time to revise it. That's how long it's been since I first wrote House Bill 3453 to change this horrible situation in which, for a government purpose, to satisfy a government lien, any government, well, especially city or county, can come around and sell their property for the exact amount and not to exceed that amount of an unpaid lien. Betty and I have been waiting 15 years for this necessary reform to pass the House and the Senate and become law. And Jack has been dead for exactly that amount of time, because that's what happened to him 1 month after they did this to him. Sold his house for the exact amount of a sewer lien, which years later the Oregon Appellate Court said was illegal. That's not the issue here. The issue is we need to fix this law that allows this to happen. And Betty would say the same thing. She's no longer living in Oregon. On my way up here, I realized that this bill, that this law, 223525, it not only violates one of our Bill of Rights amendments, the 5th, which says property shall not be taken for a public purpose without just compensation, and by that the founders weren't talking about just barely or not at all. It also violates the 4th, because we all have a right to be secure in our homes as well as our persons and effects from unreasonable seizures. And it also violates the 8th, which says excessive punishment or fines shall not be imposed. Cruel and unusual punishment, excessive fines shall not be imposed. These folks were fined $65,000 for a $5,000 sewer bill. And subsequently, after a 5-year legal battle, Jack Neely died of a heart attack precipitated by stress over that battle. So that's the prelude. I have some brief remarks. There's already an attempt to undermine under this bill with some amendments so that property to be foreclosed on can be sold to just the highest bidder with no minimum bids. The League of Cities seems to be behind that unholy position. Just how would that work? Let's say the house was $70,000 assessed at and the lien was for $7,000, which was the case here. If the highest bid on the property was $5,000, would that be enough to sell the property? Probably not. Because the same cities that are against this bill, probably primarily Portland, would probably want all of their money. Wouldn't you? I would. I don't even blame them for wanting their money, all of it. As long as the lien is valid and they're entitled to it. But by the same token, the property owner is also entitled to all of the money that he has invested in his property. That is beyond the actual value of the lien or liens against it. At least if property rights are to actually mean something anymore. I also agree with that. Wouldn't you? In the process of perfecting a lien, no government should be able to sell, transfer, or should I say, steal a property owner's valid legal investment in their property. It's an even more egregious assault on the Bill of Rights when the property that's being foreclosed on is an owner-occupied residence, and the owner is put out on the streets and caused to become homeless over it. It's even worse when he's a senior citizen, 76 years old, and all of these things did happen. And what would you say if I told you, well, you already know, that he died of a heart attack, induced by a 5-year-long legal battle with the city of Eugene, and that Lane County courts and the sheriff's department piled in at the very end? Is there one of you that's not moved by this story? Then do something to fix this. This law, 523.525, and others like it, so that this doesn't happen to anyone else ever again in our state. The government's only legitimate interest in such properties is their valid lien against it. The law is about providing equal justice to everybody. Lest it should be said that the umbrella of the law just ain't big enough for everybody to fit under it. I'm so tired of being treated like a second-class citizen in my own country, by my own government, and having politicians ruling over us who don't have common sense or moral compass. I'm sure that Jack Neely went to his grave feeling totally disillusioned and discouraged with his country. Whether it's the Patriot Act, or the National Defense Authorization Act, or just the act of taking somebody's property without just compensation for a public purpose, which is to satisfy that lien, which is where that money went to go, to provide public services. And by that, well, I've already said this, I won't repeat it, but Jack Neely's dead bones are crying out from the grave right now for justice. And I don't want to believe I'm the only one that's hearing it and hearing him. And I'm here to tell you, not in my name.
Thank you very much for your strong and compassionate testimony. Any questions of the committee?
Mr. Chair?
Yes.
I just would like to say thanks for your testimony today, sir. Really appreciate your voice on this. It was Woodrow Wilson. I happened to Google that for you really quick. So
I thought it might have been him or Franklin Roosevelt.
And as I say this, again, very compelling testimony. You also quoted Edmund Burke in your written testimony, and he also said, all that's necessary for the force of evil to win is for enough few good men to do nothing. Thanks for doing something. Thanks for being here. Thanks for your testimony.
And you too, Mr.
Thank you very much for coming up. Safe travels, and we're going to correct this.
Thank you very much.
Okay, well, with that testimony, then we'll reclose the public hearing on 4111.
You're tuned to Sunday at noon on KLCC. Scott Rohter recently took the DMV vision test and thought he was good to continue driving Oregon's roads. Rohter, a 56-year-old traveling appliance repairman with more than 280,000 miles on one of his 2 pickups, often commutes home to Vida from Eugene Springfield after midnight. In December, someone convinced the DMV he needs to retake all his driving tests or turn in his license. The DMV refused Rohter a copy of the accusatory report, saying he could obtain it only through a hearing or lawsuit. Rohter, in conversation with Claude, picks up the story.
On December 20th, or shortly after that date, I received a letter saying that DMV had received a complaint, a report of my driving, and they were questioning whether I was a safe driver, and that they're requiring me to retest and re-examine.
How long had you been a driver?
40 years.
And what was your driving record? And do you think it was a factor in all of this?
I do think it might be a factor because my driving record has tickets on it, but nothing on my driving record indicates that I do not have the ability to drive safely, which is the principle under which they're required to review somebody's driving for a retest. Nothing on my record in the way of tickets indicates I don't have the ability to drive safely.
And the DMV nevertheless told you you'd need to retake your written, driving, and vision tests within 60 days or turn in your license.
Yes, by February the 20th, I'm supposed to complete all these tests. And in July, I just passed the vision test and got a driver's license renewed.
And who had called your driving into question?
Well, the letter didn't say, and that's what got my level of anger up. It said nothing about where this report or complaint of my driving came from.
Were you told why you couldn't be told?
Numerous times I was told it's confidential and they can't tell me. This program of what they refer to as non-mandatory reporting of instances of alleged unsafe driving has been going on for 20-odd years, since 1987, and they accumulate anonymous reports at the rate of 2,000 average a year. For 20 years, we have 40,000 secret files being maintained at the DMV about Oregon drivers. I frankly don't see why any report should be kept secret. This is not Homeland Security or the CIA. There's no reason for secrecy.
Well, apparently there was concern on their part about protecting family members or other citizens.
Protecting them from what, though, Claude? What is somebody going to do if their driving is being called into question? They're going to hire a hitman? I don't think so.
The other thought was that they would be discouraging people from reporting errant drivers.
Well, and they rightly should be. Are we trying to build a nation of weasels who go around snitching on each other privately? Or do we want people who actually have a legitimate complaint or concern to openly report? And I just think most folks have no problem reporting openly.
We're speaking with Scott Rohter of VITA, who has been asked to retake his driving test and who has questioned the manner in which his name was reported and brought to the attention of officials. Scott, have you heard from others who've been affected in the same way that you have?
I've had several, probably half a dozen calls about this from different people. It's just not me. Well, you'd expect that. There are 40,000 secret files here over 20 years. This has been going on until the DMV claimed that I just brought it to their attention.
The Register Guard on the 30th, again, an article by David Steves, made reference to the fact that there's been some partial closure of the situation. Could you tell us about that?
They're willing to make those reports generated by cops available with just a request for public information about your file. But that's 50% only. There's another 50% or 20,000 secret files that don't originate with law enforcement, that come from family members and friends, doctors and healthcare providers, that come from, believe it or not, just someone on the street. Those reports should be dealt with at the same time. There's no reason to keep these reports confidential. If we have these reports, they can be fabricated, unsubstantiated accounts. There are no safeguards, although the DMV claims that there are some. There are no safeguards to keep this anonymous reporting from turning into abuse.
Scott Rohter of VITA, in conversation with Claude, he's taken on the DMV over denying him the name of the person that accused him of erratic driving, requiring him to retake his driving test. To comment on Scott's situation or to share your own DMV-related quandary, you can reach us now at 463-5522 in Eugene, Springfield, or at 800-922-3682.
Oregon DMV spokesman David House is our guest. And David, I have to give you a chance to respond, if you'd like to Scott, who, by the way, is on the line, and I think he'll have a little coda to put on to that piece, but we'd like to hear from you on that, too.
Sure. What Scott's talking about is what we call the non-mandatory reports. That's as opposed to the mandatory reports that physicians in Oregon are required to provide to DMV if somebody has some kind of medical issue that makes them unsafe behind the wheel. When the medical requirement was revised back between 2001 and 2003, they also revised the administrative rules. And for some reason, and I'm not sure why, the piece that eliminated law enforcement from the confidentiality option was removed from that. And Scott Rohter's case brought us that to our attention. And so we started the administrative rules process to put it back the way it had been for the previous 15 years, because there's no reason to make law enforcement have the option of confidentiality.
So you're saying that you're moving to a situation where the person who reports someone for errant driving that leads to his having to retake the driving test would always be known by the person who's affected by that report?
No, if it's other than law enforcement, those people have the option of checking a box that says, please keep my name confidential. Of course, that confidentiality only extends up to the point where there's any kind of a legal proceeding, such as an administrative hearing or a lawsuit.
David, has DMV secured a legal opinion on maintaining non-police reporting confidential?
Yes, we have lawyers at the Department of Justice, and I think they agreed with us. Let's just put it back the way it was the previous 15 years.
But how does this square with the constitutional right of being able to face one's accuser to assure such accusations are neither false nor malicious?
Mm-hmm. Because we've placed safeguards and a chance to appeal the decision through administrative hearing. Essentially, you can't file an anonymous report. It has to be, you have to identify yourself, and you have to identify the driver. You can't just look at a license plate and turn that person in. We won't accept anything like that. And you have to name specific driving observations that you've made that are unsafe before we'll even consider the report.
Well, Scott is with us, Scott Rohter, who you heard from in this piece just now. And Scott, welcome to Sunday at Noon.
Yes, thank you for having me on. And hello, David.
Hello.
You're on, Scott, for anything you'd like to add to what you already have told me.
Well, I don't know where to begin. David sounds like a thoroughly nice gentleman, but he's entirely misguided. I didn't quite understand the response when your guest host there asked him whether he was going to maintain the secrecy level for reports not originating from law enforcement. That answer wasn't clear.
Well, David, you want to give us another quick take on that?
Yeah, the form that, say, a family member or a physician on a non-mandatory report has a box that you would check to request confidentiality. You don't have to request that. We're going to leave that the way it is for people who are not law enforcement.
Okay, well, can I say something, Cliff?
Yeah, as long as you don't go too deeply into repeating what you've already said, Scott.
No. There are 7% of reports that originate from the DMV and the courts itself. Under what basis does David House think that those reports from officials of our government should be maintained secret? I claim they should be open, as well as reports from law officers. And as far as the family members, there is no reason to provide secrecy to family members, because what we're going to have here is a few people who don't want to confront their grandfather, when most people would be willing to tell their grandfather to their face that they're beyond their safe driving years. And so we have, because of a few people every year who are non-confrontational, in other words, they hate to confront anybody about anything, we have now 20,000 more reports that are being claimed confidential and will not be available to the person they pertain to.
Okay, Scott, well, thanks so much. You've made your points well, and we'll see how some of our listeners might respond to it. Thanks so much for the call.
Agenda item 5D from the consent agenda, which has been pulled up as an action item. Mr. McMillan is going to introduce this for us. This is the temporary amendment of OAR 735-076-0005 relating to the release of a non-mandatory report submitted to Driver and Motor Vehicle Services. Tom?
Members of the Commission, my name is Tom McClellan. I am the acting DMV administrator. And the item before you is a temporary emergency rule change that affects the reporting requirements and the release of information for our at-risk driver program. Specifically, those reports that are not mandatory. They're not those required by the primary care providers in the state to report concerns of health-type issues, ability to operate a vehicle safely.
Thank you, Mr. McClellan. We have one person sign up. You can just step back. We have one person sign up for public testimony, Mr. Scott Rohter.
My name is Scott Rohter, and with respect to the temporary emergency rules changes proposed by the DMV, pertaining to non-mandatory reports, these rules changes, although welcome, are inadequate. None of the reports at all should be kept secret, in my opinion. There should be no secret files at the DMV, whether they're mandatory or non-mandatory reports. A resident of Oregon should be able to access their own file and driving record with a simple written and signed request which would meet privacy requirements. The proposed rules changes should be expanded to cover all reports coming from family, friends, and others, the courts, the DMV itself, and to reports coming from doctors and healthcare providers as well. There is no advantage to the public in general, nor to the individual making a report, nor to the person about whom the report pertains, to keep these reports in secret files. We should stop this practice. Also, unsubstantiated and unspecific allegations should not be considered by the DMV in evaluating a driver for possible retesting, whether they're made directly to the DMV by someone or they're included in a report coming from police officers, as was the case with me. With respect to non-mandatory reports coming from officers, I don't believe that any police officer should be making any report to the DMV without court oversight, without a citation being written, and either a guilty plea being entered or a conviction being obtained. To do otherwise is to short-circuit the judicial process. Police officers who stop someone on the road are neither medically qualified as a doctor to determine that someone is not able to drive safely, nor are they intimately familiar with the individual as a family and a friend might be. There are other changes as well at the DMV that deserve your attention. When an individual is required to retest under this at-risk program, they should be allowed the option to take a handwritten test if they so choose, and not just one prepared on a computer terminal. And their test, containing their own answers, should be made available to them after the test has been evaluated. There is no advantage in keeping the questions nor the person's own answers secret. For that matter, there is no advantage in keeping the answers secret at all. First, it would help those who gave a wrong answer to be able to go back and learn from their own mistakes and become better drivers. Second, we want people to know what the important rules are concerning driver safety so they can focus on them and learn the rules of the road. The notion that to give someone their test back with the questions and their answers on it would compromise the test is ridiculous. We want people to know how to drive better, don't we? If you're worried about someone using a cheat sheet, just scramble the order of the questions and use multiple tests, and in this way there would be an almost endless variety of different tests. No one could go in with a cheat sheet and be prepared to pass the test without actually studying the questions and actually knowing the correct answers.
Mr. Rohter, your time's up, so if you can
Thank
just
you.
wrap it up, that's fine.
Just one more point. The records-keeping system at the DMV is flawed. An accident looks to me to appear on the record just the same whether an individual is considered to be 100% at fault or 0% at fault by their insurance companies. And that needs to change. A minor parking lot scrape now backing up looks as bad as if there was a high-speed collision with extensive property damage and bodily injury. In some cases, the damages are under the minimum amount requiring you to report, yet one of the person reports and the other doesn't, and that appears as a suspension and a failure to report on your driving record. If a deer jumps out into the road before an oncoming car and a crash can't be avoided, it too appears on the DMV record as an accident, just as if someone deliberately ran a red light at high speed and crashed into oncoming traffic. The DMV can do better than that. And one other thing. After a certain age, I would like the commissioners to consider reducing the amount of time that someone would get a driver's license for. I have a neighbor whose father is 98. He just received a driver's license for 8 more years. That's silly. I think you can come up with a better program than that, and it would be one that might allow them to come in every year with a one-year renewal and a mandatory retest, and it wouldn't put the onus on citizens having to file secret reports about their neighbors. Thank you very much for listening.
Thank you.